So basically, we went through. We had a, Heather and I came up with a series of questions that we thought would be incredibly impactful to have some lawyers discuss things that really impact security professionals, companies, across a number of different areas. And obviously, we have two very smart, very talented lawyers, and we'll go through their backgrounds there in a moment. But we basically have the ability to ask some questions of folks, and then obviously answer any questions that come in from the audience. Obviously, also too, I wrote this really great disclaimer, so I'm going to read it. But basically, I did want to preface this discussion that obviously neither of the lawyers here present are your lawyer. None of the things that we'll be discussing is actual legal advice. You should always talk to your own legal counsel before you make any decisions. And despite the fact that we have two very talented, very smart lawyers, and we'll get into their backgrounds in a moment, but despite the fact that we have two very smart lawyers here, they're not your lawyers. I certainly am not a lawyer. You do not want me doing anything legal for you. I failed the bird law bar. I'm especially atrocious at these sorts of things. So don't take anything that we'll be discussing here. And obviously, if you do have questions about anything that is discussed here, and you should talk with your own legal counsel there. So, sound fair to anyone? Naomi or Fred, do you want to add anything to that? Nope.
Sounds good.
Perfect. So to just kick this off, Naomi, do you want to go back into your background, talk about what you do and that sort of thing, and then Fred, you can do the same?
Sure. Yeah, my name is Naomi Gillens. I'm a lawyer at the Electronic Frontier Foundation. And first off, just thank you so much again for having me. Always glad to talk about the CFAA and really glad to be here with you guys today. So a bit about me, I litigate cases at the intersection of technology and civil liberties, right? So when there are new technologies that have ramifications for privacy, maybe it involves government surveillance, implications for free speech and dissent and protest, that is where I am working. And it might not be immediately obvious how the CFAA is relevant to that, but I think that will come out during this conversation. Before I joined EFF, I was at the ACLU working on very similar issues. And before that, I was working for a few federal judges and a student at Harvard Law School, where I was also an affiliate at the Berkman Klein Center.
So you have an incredibly impressive and impactful career, and continue to do impressive and impactful things. That's an amazing background. So
love flattery. Thank you.
No, that's wow. Okay. When Heather suggested you join, I knew you would bring this sort of background. I did not realize the level to which you work in these sorts of spaces, and that's amazing. Thank you again for all you do and what you bring here today.
Thank you for having me.
No, of course. And then Fred, you obviously also have quite the background too. You and I have known each other for a few years, and you also work with some of our hosts here as well. But do you want to talk about your background and what the sorts of things that you do?
Sure. So I am Associate Corporate Counsel at GitHub, and among many other hats I wear there, that includes I'm the primary attorney working on sort of legal support for our security incidents, for our bug bounty program, for a handful of other things in sort of the technical security space. I've also worked with our policy team on advocacy in this area and others. And I've been with GitHub for about a little over not quite 2 years at this point. Prior to that, I was at Tor Eklund Law for about 4.5 years, primarily doing cybercrime defense. Have second chaired CFAA criminal trial, have handled many civil and criminal CFAA cases, from search warrant through to Supreme Court appeal. And it is a delight to be here talking about it. I should also mention, sort of in the AppSec world, I also have authored GitHub's current bug bounty, which was shortly thereafter adopted by Microsoft. So I've got some things to say in that area too.
No, that's perfect. So that leads us right into the first question. Is I think you both work for incredibly impactful organizations. Obviously EFF is at the forefront of defending all sorts of rights and all sorts of like the ability to actually continue to do the things that we as security researchers do. And then GitHub is no less impactful, but from a technical side, really in helping people actually share research and whatnot. But could we talk about what CFAA is and talk about what the actual impact that researchers and other security folk would see based on both of your experience and background with the law and those sorts of things? Naomi, do you want to lead off there?
Sure, happy to. What is the CFAA? This is the federal anti-hacking law. It was passed in the 80s to target malicious computer break-ins, right? So it was actually passed in response to the movie War Games. I don't know how many of you have seen this movie, but the lore goes that President Reagan saw this movie. It's about a kid who thinks he's, playing a video game and is in fact starting World War III. And this was seen as a very realistic depiction of the kinds of threats that the new up-and-coming computing systems might face from attackers, and got the president very concerned and got Congress very concerned. And there were other laws at that time that could target malicious computer break-ins, right, like there are today, like wire fraud. But Congress wanted to do something more, and so they enacted this statute, the Computer Fraud and Abuse Act. And what it does is it's very lengthy, but it prohibits accessing a computer without authorization or in a way that exceeds authorized access. There are a lot of different provisions, but they all include this language about authorization. And so the question is, what does that actually mean? And the statute doesn't tell us. And it was enacted in 1986, right? So we did not have the modern internet or modern computing. And these questions about what this language actually means, like these are still being batted around in the courts now, like right now, like there's a Supreme Court case about this question, this term, because it's just totally unclear. Fred, do you want to talk a little bit about the impact that confusion has on researchers?
Yeah, sure. No, that's an excellent intro. I think probably the biggest and most harmful aspect, whether we're talking about the access provisions or the damage provisions, and there's a whole other, can of worms about whether your authority to access is also your authority to damage or not. But I'll leave that aside for now. I think one of the most pernicious things is that in several circuits, and this is what the Supreme Court case is hopefully going to be touching on, they still adhere to what you could sort of think of as a contract theory of authorization. So if the terms of service for the website or the URL that you click through says don't do this, that is not just a contract term, but is a condition of your authority to access the site or the software. Obviously, if you are a security researcher, if you are taking programs or systems or hardware apart in a way that probably violates that term, that is essentially putting you at risk of felony culpability for doing necessary security work. The other sort of lingering horror of this having been passed in the mid-'80s is the bar for charges becoming a felony are extremely low. It's $5,000 or more in damage or loss, and those are both defined further in the statute. And back in the mid-'80s, that was probably a lot of money for a early computing industry. Nowadays, pick your smallest security consulting shop, and they'll do that in, an hour or two of incident response.
Mm-hmm. Yeah, I've definitely exceeded that in potential risk damages or in potential, obviously simulated, granted by a client, that sort of thing. But any number of things that we do could easily exceed that sort of thing. I mean, even in programming hour, like programmer hour, we could easily exceed that number there. So that's super interesting. So the CFAA obviously hilariously comes from war games, which I obviously and I love the movie and whatnot. But I think it also has some other further reaching implications there. So obviously folks who want to like modify healthcare devices or work with insulin pumps, that sort of thing. You're very clearly voiding your manufacturer's warranty. You also can famously do this with like John Deere tractors, right? So the tractor has a no right to repair, and now anything that you do is technically violating these sorts of things there. So can you talk about the implications from your own background as well as from what you see in GitHub or at EFF about these sorts of things? Like, how are we actually impacting right to repair and right to modify? Fred, do you want to start off?
Oh, did I lose you?
No, I don't think so.
I was going to say, I don't want to wander too far into DMCA anti-circumvention territory, and that's where you get into the John Deere tractors, the repair, the right to avoid your warranty, and that is a fascinating area, but is a talk unto itself. I do think that the tractor and farmer community getting into right to repair is the best thing to happen to it in years in terms of attention and power. But as far as the CFAA, I think what worries me is more and more devices and technologies and things that have traditionally been on-prem hardware are moving to a cloud-based or cloud-reliant structure. So, even if my 1201 exemption covers my right to repair my tractor or my right to perform security investigation on my, hardware firewall, once those become cloud services, now I am logging into a system that someone else controls and probably doing it through protected computers active in interstate commerce. And, I think the more of our sort of day-to-day devices whose security or modification or repair relies on those internet connections and cloud interactions, the more the CFAA becomes a looming threat for those communities as well.
Yeah, that's absolutely right. And then on top of that, the CFAA, at least some courts' interpretations of the CFAA, the broader interpretations, which Fred was talking about earlier, would also prohibit like violating terms of use. That encompasses so much. And there are so many instances where you have security researchers doing, like basic public interest security research, right? Reverse engineering devices or software and trying to figure out where are their vulnerabilities, where could there be data leaks, right? Where could malicious attackers be accessing like really important information? And in order to do that, maybe they violate a prohibition on, saying no reverse engineering, right? That's a very common term, or all sorts of things. And there are all these prohibitions in terms of use that maybe don't even make sense, right? Or are just like copied and pasted. So EFF's favorite example of this is like the website for 17 magazine that used to say no visitors allowed who are under the age of 18. Right, until EFF like publicly called them out for that. And that's obviously just a case of someone copying and pasting the terms of use and not even thinking about it. But it happens all the time. And then you get, it turns into a federal crime if you violate that. And so you have researchers who have done extraordinarily important research, finding like vulnerabilities in insulin pumps, for example, right? You have Jay Radcliffe is an example of a researcher who he did research into his own Medtronic insulin pump to try to figure out what the vulnerabilities were and discovered that attackers could potentially get into that pump, control the insulin levels, deliver potentially lethal doses of insulin. And by exposing that, he was able to get Medtronic to actually fix that software, right? They fixed it. Then he found more vulnerabilities in the updated version, and then they fixed that. But that's incredibly useful, right? It's so important in this ecosystem to have security researchers doing that work. And, luckily for him, he did not run into legal liability for doing that, but he has no guarantee of that. And that is the problem, is that if Medtronic had wanted, instead of welcoming that research, had wanted to turn it against him and go after him for violating their terms of use, they could have done that.
And I'll add, that is not just a hypothetical. I have absolutely had clients in private practice who were in the medical tech security field and absolutely had med tech providers say, how dare you expose our security flaw? Here's a civil CFAA claim, or here's, my buddy at the local FBI office after you now. And it's nasty.
Yeah.
Interesting. So can you talk about the two risks there? Like you said, there's the civil side, right? That's obviously interesting. Like, how much can they go after someone for? How much can they really, like, how bad can that be? And then if they do refer it to the FBI or even saber rattle in that direction, like, how far into that can they actually get?
So the first one's easier to sort of hypothesize on because anyone can bring a civil claim, and it's a relatively structured process. If you see it probably most often in the real world with ex-employees who had some sort of privileged access and then ran off and started like a competing company is sort of the classic civil CFAA example. Or a web scraping situation, like the LinkedIn case is a good example where, some other company is scraping your public data and turning that into some sort of profitable item that you don't want them to be doing. In those situations, no one's going to jail. It's a civil claim, and it's, if I'm remembering right, I'm forgetting right now off the top of my head if this is every circuit or just some circuits. It's also subject to that $5,000 floor, which again, in this day and age, is pretty trivial to meet. So, I mean, if a case goes forward, a private party could bring claims for their damages and losses caused by that activity. A criminal case is a little more complicated and gets into what I've described sort of as the social and cultural factors around criminal prosecution. Back in 2014, I think it was, the DOJ sort of released their internal charging guidelines for CFAA cases, and at sort of a high level, they're not unreasonable. They look at things like the sort of social harm caused by what's being done, the amount of damage, the amount of like user base or public harm coming from the activity, and draw a not outrageous line for what case is actually worth bringing and what case isn't. There's sort of two problems with relying on that as a sufficient backstop. The first is, that's DC. They can set sort of guidelines and suggestions and policy. The individual U.S. attorneys' offices in various states and federal districts have a lot of independence and a lot of power, as do individual prosecutors within those agencies. So part of this is you've got career incentives where if I'm a junior prosecutor, cybercrime is sexy. I want that, on my resume. And if it means going after someone because they, visited 17 Magazine's website and they were 17, so be it. You've got that discretionary aspect. You've also got the aspect that, if I'm a security researcher, just the process of being investigated, having my devices seized, having my home searched, even if no charge is brought, that can be life-destroying. And the problem is to even answer some of the questions in this DOJ charging manual, you're already beyond that point before you can answer them. So it's not really a sufficient protection. The other piece here is, the reality is larger companies tend to have law enforcement contacts, tend to have leverage either nationally or at least within their community to say, hey, you over there, why don't you go look into this? And I don't know, just the guidelines coming out of DC have not seemed to do a whole lot to minimize the abuse of this overbroad law countrywide.
Yeah, and I'll just add a few points onto that. First of all, something I would add is that there are a few cases sort of working their way through the courts right now about how exactly we interpret the CFAA. One of these cases is called Sanvig v. Barr, and in that case, it's an ACLU case that I worked on when I was at the ACLU. And it's representing computer scientists and academics and journalists who do research online looking into algorithmic discrimination, right? How do algorithms on employment websites or housing websites discriminate intentionally or unintentionally, right? Based on characteristics like sex or race. So these are extremely important questions, right? It's obviously in the public interest to get to answer them. And the argument is that these researchers aren't able to do the work because by doing so, they would have to violate terms of service, like prohibitions on making these tester accounts or using accounts with any false information, which you would have to do, right, if you're testing out to, identical accounts that are different only in, gender or race. So, okay, so as part of this litigation, the court gave the government the opportunity to disclaim its intent to prosecute these people, right? And this case would have gone away if DOJ had just said, look, we tell you, court, we will never prosecute someone doing this kind of public interest research. And that's not what happened, right? Instead, what happened was they pointed to these charging guidelines that Fred is talking about, and they said, look, it's our policy that we don't, probably we wouldn't be going after these people. Look at our policy written down here. But they wouldn't actually make a representation, right, under oath to the court saying, no, we're actually not going to prosecute these people. So that's the first thing. And then, even though these prosecutions for sure are rare, right, you don't have the federal government prosecuting the 17-year-olds going to the 17 magazine website all the time. It doesn't happen that often, but it can happen. And the fact that it can happen has real repercussions for how comfortable researchers are doing their work. And that's especially the case. I mean, first of all, there's individual risk, right, that you take on. Are you willing to possibly go to court and defend yourself and hire a lawyer? Is your employer willing to take that risk, right? The university that you work for or whatever it is, like, are they going to support you in doing that and potentially bringing on that kind of court fight? Do you hire grad students, right? Or do you employ people who are maybe here on a visa? Are you willing to expose them to that risk? So even just having this law on the books, even if it's not enforced very often, has real ramifications for security.
Oh, wow. That's like super interesting that you bring that up, because when you mentioned that, the first thing I think about is it Blackbox Attacks, adversarial machine learning, Nicholas Paperno, I believe. He had basically trained algorithms using AWS and was showing that the adversarial machine learning was possible, not knowing their algorithm on AWS. So, by all rights and what we're discussing here, that he would have been, eligible for CFAA. But I mean, this is a research group. Sometimes they're not all even in the US. Sometimes they're in Canada. Mm-hmm. But that's interesting how that could totally derail that line of research.
Yeah.
And excuse me, how far into researchers can they actually lean? So let's say I didn't actually do the testing, or you can't prove that, Stefan did the testing. However, if you look at my GitHub, there is a repository that has all the steps in Markdown. Maybe I wrote some Python scripts, some Go, whatever it was. Like, how far into a researcher can you lean and say, like, you actually, are meaningfully impacting us? Either one of you is fine to answer. We both have different sides and views to this sort of thing.
I think if I'm a creative prosecutor, 18 U.S.C. 371, the conspiracy statute, stretches pretty far. Probably, if there was no evidence that you had any connection to this group that actually used the code, but you'd written sort of detailed instructions, arguably no, not conspiracy. There are some other sort of cybercrime adjacent laws that might be brought in. I'm thinking of Marcus Hutchins's case specifically, where they brought in like access device fraud type charges as sort of a fallback in case the CFAA didn't catch for that reason. But the range of charges just for making that sort of stuff available is not small, and certainly if you can tie them to the group that actually used it, even if it's tied through a legitimate research institution, I don't think a prosecutor would have a hard time bringing conspiracy charges on that.
Yeah. I mean, there are arguments that prosecutors or companies can make about, look, this was an issue in the Sanvig case, was we had these researchers who literally what they wanted to do was make 2 tester accounts, right? One account to look for, upload a resume and look for what jobs are offered. And then a second account of a different, say, gender, right? Uploading a resume, seeing what jobs are offered. They're not applying for jobs. They're not interacting with people. They're not posting jobs. And you have companies saying, it's very important to us that all of the accounts be real people with real names, because otherwise, people won't trust us. They'll think we're awash in fake accounts and bots. And so there's this like unquantifiable damage that you are causing. And even though we can't quantify it, that is real harm, and it enables us to go after you. And that is a stretch of an argument, right? Like that seems crazy, but that's the legal argument that folks can make under this law.
Interesting. And then the point that you brought up, Fred, about bringing in cybercrime adjacent laws, is that sort of like stacking? Like you charge someone with one crime and then charge them with a crime that's almost the same, but not exactly. It has slightly different nuance, different law, etc.
Yeah. So I mean, subject to the limits of one's sort of district office's policies or the charging guidelines issued from DOJ Maine, there's really very few disincentives to bringing just a whole laundry list of charges. It increases the sort of terror factor for the defendant, so you've got more leverage to get a plea. It gives you sort of fallbacks if, say, some get dismissed on motion to dismiss or otherwise get sort of dropped before trial. I'd say my experience in federal courts sort of across the country has been, it's pretty easy for prosecutors to amend a complaint to add or drop charges once they sort of get closer to trial. So yeah, I don't, the best example I can think of with CFAA is Marcus Hutchins's case, but it's not uncommon, especially for conspiracy charges, to be included on if it's a sort of group effort situation.
And then Naomi, obviously you work at the EFF. You see quite a few cases come in that touch on CFAA, and obviously I'm not asking you to speculate, but in terms of how often these sorts of stacking crimes or cybercrime adjacent laws that you see come in, are they very often brought together? Like, is someone just hit with this laundry list? Is that a fairly common thing, or are prosecutors more using this in specific cases like Marcus Hutchinson or other cases that they want to make sure that they get a win on?
Sure. Well, I would echo exactly what Fred said. I mean, I think any prosecutor worth their salt, really, like, it makes sense if you are a prosecutor to stack all the charges that you can, right? It just increases your own leverage, your own ability to get a plea deal or whatever it is, make this all go away as easily for yourself as you can. So that's a very common practice.
I'm seeing we kind of have this kind of related question here. While CFAA gets most of the press, I've started to see more state-level hacking charges against kids doing hacking. Is this becoming more common, and is the EFF tracking these laws?
I actually don't know about that. It's a great question. I've been very focused on the CFAA and this federal law and trying to figure out what it means in every jurisdiction right across the country. But that's absolutely right that states, of course, can have their own sets of laws, and then you have 50 different sets of laws in every state to try to figure out what it means. And that's not only going to be dependent on where you are, right? If you are living in California, you have to figure out California law, but maybe you also need to figure out the law of whatever systems you're interacting with.
Yeah, I'd echo that completely. The jurisdictional question, once you get to a state law level, is a lot more complicated. Certainly where, let's say it's sort of a simple single attacker, single victim situation. Certainly jurisdictions fine where either of them are. If the route from attacker to victim goes through, a server in Arkansas and bounces off a VPN that's located in Mississippi, jurisdiction gets a lot more complicated real quickly. I can't speak to sort of whether that's becoming more common either. I will say it's becoming more common for states to have their own sort of CFAA-like laws, and they often introduce complications that are more nuanced, both for better and for worse, than the CFAA. So California's state law, for example, gets into a lot more technical detail than the CFAA does. And because of that, it has a few different limits, but it also has a lot more reach in some ways.
A lot of what we do at EFF is counseling people who want to do a research project and need to know, like, what kind of legal liability am I incurring, right? And there's not always clear answers that we can provide. A lot of times it's just a matter of saying, like, look, these are the sort of known unknowns. These are the risks that you're taking, and laying them out. And that's sort of the best we can do. And then it's up to that person to decide whether or not those risks are worth it for them.
This might be a very silly question, but when does something become CFAA versus the local state equivalent thereof? Like, when am I going to go to big kid court for CFAA abuses versus, like, maybe the junior varsity league of, like, a state that maybe doesn't have such great, like, when do I want to risk this? No, I'm not asking you to speculate on that. But, like, when do things become a federal impact versus when do things, like, exist only at the state level? Naomi, you probably deal with this quite a bit in your counseling, and then obviously, Fred, I'd love to hear what you think. But when is it federal versus state?
Well, the answer is that it can be both, and that you can be prosecuted in both jurisdictions too for the same activity. Unfortunately.
Yeah, it doesn't sound like there's good answers to any of these questions that we've come up with thus far.
Not good for any of us. Maybe good if you're the prosecution.
Right.
None of us are. So, no, please, Fred.
Oh, yeah. No, I was going to say that's exactly right, and I think the most disappointing day of my criminal procedure class in law school was realizing that double jeopardy does not mean that you can't also be simultaneously charged by the state court. Which one gets sort of precedence if you've theoretically violated both is a really hard question to answer, because it's not clear from the outside sort of when DOJ pulls rank and says, hey, no, this is for us. There are limits on the CFAA based around some sort of arcane definitions of what's a protected computer and what's used in interstate commerce. But the reality is that today the case law has kind of defined a protected computer and in interstate commerce really broadly. So if you're not using a handheld calculator that was made in state, you're probably using a protected computer in interstate commerce.
Ouch.
Oh.
Yeah. And as a practical matter, if you have a project that you're thinking of doing, you're not going to be able to make that distinction ahead of time. It's if you are violating someone's terms of use, then you need to be thinking about the state law and you need to be thinking about the CFAA.
Interesting. And then obviously the target is problematic, but also where I'm launching these things from then. Like, so if I like using Fred's example earlier, it bounces around and whatnot. But can I then effectively be charged in each state with every interstitial device that I've touched along if someone figured this out along the way?
So last I looked into the case law, that is still a somewhat open question. It is, you've got sort of appellate level federal cases saying, no, the internet isn't everywhere just because it's the internet. It has to have some sort of locus to, a defendant, a victim, an affected organization. But I don't, Naomi, if you know better, I'd love to hear it, but I'm not aware of any court that's said clearly, because this routed through a server here, you've got jurisdiction.
Yeah, no, I agree. But I would also back up and just emphasize that, like, what's really important and concerning about these laws is the high level chilling effect and power that they give to prosecutors and to companies, right? Because if you are thinking about some kind of important work you want to do, like, maybe you're not thinking about, like, which exact states is this going to be bounced through and what are all the different jurisdictions where I can be prosecuted in, because if you are a computer security researcher who wants to just do your computer security research and help the world be more secure and privacy protective, what matters is like, are prosecutors going to come knocking anywhere, right? It doesn't matter what state they're from or if they're the feds or, maybe it will matter if that actually happens. But when you're weighing whether or not to do this project, it's, am I opening myself up to legal liability? And if the answer to that is yes, which all too often it is, right? Or maybe, then that is a real problem and it really chills research. And there are so many examples of this. So one that we talked about in our brief to the Supreme Court was the Equifax data breach, right? That we all remember from 2016, where 140 million people had their data exposed. Someone had discovered that vulnerability, right? An independent security researcher found a vulnerability on the Equifax website, knew that it could be used by attackers in order to get this information, wrote to Equifax and said, hi, I uncovered this vulnerability. And the researcher in interviews afterwards said it would have taken them 5 minutes to fix, like they just needed to shut down this website. It would have taken 5 minutes. Then they could have fixed it and carried on. And they just totally ignored the researcher instead. And so now this researcher is in a bind, right? Because they have alerted the company, putting themselves at some legal jeopardy for doing so, because it could show, right, that maybe they violated some term of use in doing that research. And when the company doesn't respond, then they have the further question of, okay, well, now what do I do? Like, you could go to the government, you could go to the public, go to the press, right? Create a website, tell people about this, which in doing so, like, that's going to force the company to respond, right? If you go to the public, the company is shutting that website down for sure. But it also increases the chances that they're going to be going after you, right? And that they're going to be really pissed at you and try to bring charges against you. And so that person understandably didn't want to take on that legal liability and didn't go public with this, right? Didn't go to the government with this. And just a few months later, we have this huge data breach that was completely preventable except for this archaic and confusing legal structure that has all of these incentives that disincentivize people from making our computer systems more secure.
Well, and Naomi, you also brought up an interesting point, given how I mean, everything you've said is interesting, but one of the things that stuck out to me is since it's so incredibly arbitrary, who defines where this start is or what the problem is or those sorts of things, it almost sounds like the company might be okay with it, but someone in between may have an issue with it. So like if I launch my attack my proof of concept from AWS or Vultr or some VPS provider, they also could take umbrage, launch a CFAA charge against me in any capacity, and then kick the ball off rolling, even though the target organization was perfectly okay with this attack or this issue going on.
Yeah, that's absolutely right. And you have so many systems now that are extraordinarily complex, right? So you have talk about like a mobile voting system, right? Like this company called Votes that now makes an app for your phone that you can look at, and Trail of Bits audited them, right?
Yep.
So if the company is paying you to do an audit, that's great. But my understanding is that Trail of Bits was not looking into all of the third parties that Votes contracts with, right? So Votes makes some of the software themselves, and they also hire other people or use other people's software. Okay, so you have an audit that looks into the security of Votes, but is not looking into the security of all of those other people's work. Okay, so then how secure is Votes actually going to be? Even if an audit says, great, perfect, everything we looked at is great, which is not what the audit said, you still don't know because there could be a vulnerability at any step. And if you look into those other companies, then you're exposed.
Yeah, this comes up in bug bounty sort of policy setting and safe harbor clause context a lot too, because, like you say, exactly, like things are so interconnected and relying on sort of vendor systems now. I think any good bug bounty policy today needs to address third-party systems and sort of what their stance is as to those systems. So
that's another interesting one. If I found a vulnerability that does not impact the client, right, that the target of my bug bounty or my research or anything, but does accidentally send, 11 million text messages throughout it, and there's some material cost to that. Could the company that I impacted transitively would they go after the original client who started this, or would they go after me as the researcher? And obviously, I'm asking you to speculate here, which I know is not. But like, do they have the right to come after me as the researcher, even though I technically had the permission of the target that I was researching?
If you've got the permission of the target you're researching, and it involved, unauthorized access or exceeding the authorized access third-party system they use, no, you've got legal risk from that third-party system, absolutely.
And I would add on top of that, there are a bunch of companies now that have vulnerability disclosure programs or bug bounties, and they say, we welcome independent research. We want our security to be great. Come, do your pen testing. Let us know if you find problems, and we will patch it. And that's awesome. But it also, is a PR tool, and it also indicates that the company cares about security, and it makes people feel like the company's products are more secure, which means that many, many companies adopt these policies in good faith, right? EFF has a bug bounty program. We will not give you cash, but we will give you swag. But not all of them do. And there have been instances where people have done testing that they thought was allowed under the vulnerability disclosure guidelines with votes, for example. That's one example where just last year, I think, or a few years ago, there was an undergrad student, right, a college student taking an election security class at the University of Michigan, who, as a part of a class assignment, was doing pen testing into Votes' app, found a vulnerability, disclosed it to Votes, and then the FBI comes knocking, and it turns out Votes referred him to the FBI, saying, look, he's doing pen testing, or he's trying to penetrate our system. His defense, of course, was, I was doing this per your vulnerability disclosure program guidelines. And what they said was, no, they pointed to a specific provision in the guidelines that, they said that he had violated. And then people discovered that actually that provision had only been added to their vulnerability disclosure program after the fact that they had referred him to the FBI became public.
It's so shady.
That is super shady. I have a case I can talk about because the client gave me explicit permission to a while ago, where almost the exact same thing happened with a well-known drone company, which very hastily rolled out a bug bounty program. I think kind of around that time when they were coming on the scene as okay, right, this is the thing we need a written policy page and a landing page for and all that. And had they rolled out this just kludged together bug bounty program that said, yeah, research anything, do whatever you need to, tell us about it. It was perfect marketing, terrible legal copy. And so, this person went out and found a critical vulnerability with a bunch of private keys out in the public where they shouldn't have been. And the company, rather than fix the problem, started threatening all kinds of criminal, referrals and civil suits, and the exact same story of just, you didn't act in good faith based on sort of your published policy.
And I think this actually is a nice segue into Madeline's question here too. In general, do charges tend to be levied against individual employees or researchers, or the actual organization they represent? And to wit as well, how far can you carry these things to, even if it is against an individual researcher? Can someone go after Trail of Bits for something I was doing transitively for another client?
In silence. I don't want to speak on behalf of Fred. For myself, this gets sort of into issues of employment law and liability that I'm not so familiar with. But certainly something that does happen a lot is that employers will be at least threatened with lawsuits or legal liability, and then you have employers putting pressure on their employees to stop doing research or to stop talking about it, right? And there have been a ton of cases over the years of presentations at DEF CON or Black Hat or other security conferences being canceled because people's employers get pressure at the last minute not to have their employees talk about some bug that they found.
I would say, with criminal charges, the only CFAA case that I'm aware of being brought against an organization is WikiLeaks. Every other criminal case I'm aware of was an individual. If we're talking civil claims, It's very common for it to be an organization, whether that's a web scraping company that they're claiming a terms violation against, or a competitor company that they're claiming, stole some secret through unauthorized access. So yeah, civil, it's not uncommon to be an organization, but criminal, almost always individual.
And then one last question before I ask you both the closing question from Null Bytes. What can a security researcher do to cover themselves and reduce, minimize, mitigate the risk? Obviously, I don't think there's any, from what you both have said, I don't think there's any actual mitigation here. But what can we do to do harm reduction and minimize the risk that I as researchers have, for these sorts of things? Naomi, do you want to lead off as the EFF person? And then
Sure.
Sure.
Yeah, I mean, for sure, you want to be, reading your terms and actually be familiar with what are the parameters, what are you allowed to do when you're interacting with this computer system. And then think carefully, maybe you are going to be violating some of those terms. Think carefully about is that actually going to be causing harm, which might not actually have such a big difference in terms of your legal liability, but might make a difference in terms of how likely you are to actually get prosecuted, right, or charged civilly. But the biggest thing I would say is, we are here to talk to folks doing security researchers who are concerned about these things. We have a project called the Coders' Rights Project, where we are here to talk with you about these questions. So email us at info@eff.org. That's what we're here for.
It's a hard question to answer because it depends a bit on what kind of security research you're doing. Generally speaking, I think of sort of CYA and risk mitigation as either proactive or reactive. Proactively, if you're a red teamer, if you're doing sort of contractual engagements, absolutely read your contract or write your contract and make sure it has really clear permissions about what access you're allowed to, what systems you're allowed to break into, what you're not allowed to break into. Just be sort of as granular as possible. Similarly, if you're doing sort of bug bounty style research, read the bug bounty terms, see how well they protect you, and factor that into where you do your riskier, more invasive testing. And that's not going to stop the government from charging you if they decide to. It is going to give you a nice formal piece of paper to hold up and say, look, I had permission, here's why. Reactively, if charges have been brought and you are in that situation, the best things you can do are don't say anything, get a lawyer, and that's kind of it. Just don't incriminate yourself.
And then obviously, thank you both very much for joining. But Fred, do you have any last thoughts? We'll start with you to keep rolling there, and then Naomi, obviously, any closing thoughts on this?
Yeah, we didn't really talk about Van Buren, and that's the Supreme Court case that's on the docket for this term. And I think any security researcher will do well to watch that closely. It is a pretty narrow question about where the boundaries of authorization lie and whether that kind of hinges on what the intended purpose was, or if authorization is authorization, full stop. And that's gonna, in the security research field, certainly that's gonna change the way that research contracts look. That's gonna change the way that, authority to access terms in red team agreements look. That's going to change a lot of things about this landscape, whichever way the court comes down. So, I would keep a close eye on that.
Yeah. And just because we really we failed to get into this, and it's so interesting, but Van Buren is the Supreme Court's chance to finally make it clear whether or not violating terms of service is actually a crime under the CFAA. So hopefully they will take that chance and make that clear and come to the right decision. We will be watching it very closely. But I guess my concluding thought is really just that, this is something that maybe seems like it doesn't affect you if you work for a company, where you're being hired to do security research, by the company. But it really impacts everyone in the broader security community because, the people with the most exposure are going to be independent researchers, right, or academics, journalists. But the entire security community benefits when anyone can discover new vulnerabilities, right? When anyone can publish their security research, create new tools, and all of these things are chilled by this law. So this really impacts every single one of us. And it's something that's sort of endlessly evolving. There are new court cases about this every single year. And even though this one, Van Buren, might clarify this particular corner of the law, there are still many looming questions about what authorization means that will continue to be litigated for a long time.
Well, thank you so much for joining. Fred, Naomi, first of all, not only for joining, but thank you very much for the work that you do. It's obviously impactful to us as security researchers. It enables us to continue doing these sorts of things. And we really just appreciate not just that, but also for taking the time to talk to us today. This was super informative. And like you said, we didn't even get into some of the questions that we had thought up here. But if you want as well, we can also drop your Twitter handles or any contact information. We will also tweet out the info email address that Naomi mentioned so that researchers can get in touch with the EFF if they do have those questions. But thank you so much, both of you, for joining today. It was an absolute pleasure.
Thank you so much for having us.
Yeah, thanks for having us. It was great to be here.
Great to be here. Take
Perfect.
care.
All right.
Yeah.